One is a reasonably good part.
Holly Walker.
Thank you, Mr Chair. Well, I'm pleased to take a call in Part 1 of the Inquiries Bill. And Part 1, of course, as has been noted by my colleagues so far, sets out the purpose of this bill, which is essentially to reform and modernise the law relating to inquiries. And we absolutely support this in the Green Party because the existing legislation governing the conduct of inquiries is over 100 years old and well in need of modernisation and updating. And I think what this bill reflects is the fact that we need the ability to have different types of inquiries for different situations. And there are essentially two different kinds of inquiries that routinely get carried out. The first is an inquiry that seeks to get to the bottom of a particular issue or incident and find out what happened, what went wrong, who was responsible, and so on. The most topical example, of course, being the Henry inquiry into the leak of the Kitteridge report, which has provided much fodder for consideration in this debate, and which I'll talk about a little bit more in subsequent calls on future parts of the bill. But another example would be the Fonterra botulism crisis, which has prompted the resurrection of this bill from the bottom of the order paper in a sudden burst of enthusiasm from the government to pass this legislation because it realised it would be quite useful to have it in place for that particular inquiry. And there are many similar inquiries that are undertaken to determine what has caused a particular event. The other type of inquiry is a broader kind of inquiry, and that is an inquiry that examines particular issues of national significance and makes recommendations, and often results in sometimes cross-party adoption of those recommendations and major policy change and steps forward in public policy. And examples of those would be the Royal Commission into Nuclear Power in 1976, the Royal Commission into the Electoral System in the early 1990s, which resulted in the adoption of our MMP electoral system, and of course the Royal Commission into Genetic Engineering about a decade ago. And those kinds of broad public inquiries are very important as well. So this bill provides in this Part 1 and this purpose clause for two kinds of inquiries which could both be established to inquire into any matter of public importance. It provides for government inquiries, which are established and led by ministers, and it provides for public inquiries, which are established by the Governor-General, which are independent of government. And within the scope of public inquiries can exist royal commissions of inquiry. Now, in practice, it's likely that the first type of inquiry, the ones that try to get to the bottom of something, some particular incident or issue, will be largely government inquiries, those initiated by ministers, and with the terms of reference essentially driven by those ministers. And the latter, the general inquiries, will be the public inquiries. But of course it does depend on context, and it depends on the seriousness of the inquiry, the gravity of the situation, and so there is flexibility within the bill for those to be applied flexibly and either could apply in either situation. Now, Part 1 outlines how the remainder of the bill provides for basically the establishment and powers of those inquiries. So it talks about how the inquiries are set up, it talks about the membership of those inquiries, it talks about the powers, duties and privileges that the inquiry will hold, it talks about the protection for witnesses, it talks about the principles that will govern the inquiry, and it talks about the sanctions that the inquiry has available to it if people don't cooperate. And all of these powers will be extended identically to both the public inquiries and the government inquiries which are established under this bill. And that is a key difference between this bill and the existing rules, because at the moment the equivalent of the government inquiries, which will be enabled under this legislation, are ministerial inquiries. That is, those inquiries which are driven by ministers. But at present, ministerial inquiries have no power to compel witnesses to appear or to provide evidence before the inquiries, as we have indeed seen with the example of the Henry inquiry, which was before the Privileges Committee this morning. And because of that, this is quite a fundamental change that this legislation makes to extend to government inquiries in the future, which will be driven by ministers, the power to compel witnesses to disclose evidence. And it's a big change, and it's an important one, Mr. Chair,
Holly Walker.
that the House should take seriously, because it is a big difference between what has existed under the existing legislation and what will exist in the future. And as we've seen from the very topical example of the Henry inquiry, it's a very salient point whether a ministerial-driven inquiry has the ability to compel witnesses to disclose information, particularly if it's the source of a journalist's story, if it is a private communication between an MP and another person, or if it is indeed privileged information under parliamentary privilege. So, in my contribution to the second reading debate last night, I raised a number of questions about these concerns and outlined the fact that the Green Party was abstaining on this legislation at the second reading because of concerns about these protections and whether they were adequately protected under the legislation. I'm pleased to say, Mr. Chair, that upon closer inspection, we are largely reassured here in the Green Party benches that the appropriate protections are in place in the bill. Now, they're not outlined here in Part 1. They come into force in Part 3. And so when we get up to Part 3, I will speak more about the particular provisions of Part 3 that I think provide the adequate protection that will allow us to support the bill, because we are very much in favour of modernising the law governing inquiries. But I want, in this contribution on Part 1, to emphasise the importance of the House taking seriously the fact that we are now extending to minister-led government inquiries the power to compel witnesses to provide evidence, because that is a big change, and it does have a material impact on the very example that we've all been thinking about today of the Henry inquiry, because if that inquiry was held under the new legislation, David Henry would have had more powers to compel evidence from those appearing before him. And so then a question of parliamentary privilege arises, and that question is whether things like Peter Dunn's email record, things like Andrea Vance's swipe card records, things like the phone records between the two of them, are covered by parliamentary privilege, because parliamentary privilege is still protected under this legislation, along with all other kinds of legal and professional privilege. And if the Privileges Committee rules that those things are privileged information, then they will be protected in future inquiries. But it's not yet clear that that's the case, because it's a live issue before the Privileges Committee. And so I think it behoves the House to have that in mind when considering Part 1 and subsequent parts of this bill, that we take very seriously the fact we are giving more power to government-driven, ministerial-led inquiries, which one would like to think, Mr. Chair, would be apolitical, but which in reality often are not entirely apolitical. And so it's very important we have that in mind as we consider Part 1 and subsequent parts. So in my future calls on subsequent parts of the bill, I will outline in more detail why we think the protections are in place to address some of the concerns that I raised last night, and why we're comfortable now to support this legislation going forward. But I'd like the House to have in its mind, as it continues in these committee stages, the fact that we are making quite a substantial change here to the powers of ministerial-led inquiries, and that we think carefully about the appropriateness of that.
Andrew Little.
Thank you, Mr. Chairman.